Tuesday, 22nd of August, 2023. Despite the cold, a warm welcome to you one and all. Thank you for joining us this afternoon. My name is Andrikus van der Westhuizen. I am privileged to be the chair of the Standing Committee on Agriculture, Environmental Affairs and Development Planning of the Western Cape Provincial Parliament. It has just gone 1 o'clock and we are meeting virtually via MS Teams. Honourable members, on our agenda today, we have deliberations on the negotiating mandate first for the Agricultural Product Standards Amendment Bill, B15B of 2021, and thereafter the deliberation on the negotiating mandate for the National Veld and Forest Fire Amendment Bill, B24B 2021. So what I may want to do today is to change our usual order somewhat around, because last week when we met on the 15th of August, we also dealt with these amendment bills. We were briefed by the national departments of both agriculture as well as environmental affairs on these two bills. And we already proceeded then by working through the matrix of input received from the public. And I do know that we as a committee also already started to express an opinion on certain of these sections in these amendment bills that were raised by the public through the public comment process. So if it's fine with you, honourable members, I'm going to ask Ms. Niekerk to ready herself to once we've been able to introduce ourselves, to be able to beam the minutes of last week's meeting that were circulated yesterday to us for consideration. But first, introductions. May I ask all the honourable members first who have joined us this afternoon to introduce themselves.
Good afternoon, Chair. Kayla Murray, member of the committee.
Good afternoon, Chairperson and members on the platform. Derek America, member of the committee.
Good afternoon, ladies and gentlemen. Peter Murray, member of this committee.
Good afternoon, Chair and everyone present. My name is Pat Moran, member of this committee.
Thank you very much. I believe those are the members that have already joined. May I now ask our guests from entities outside the Western Cape Provincial Parliament to introduce themselves, and may I start with the Office of the Premier, and then Environmental Affairs, and then Agriculture.
Good afternoon, Chair and members. My name is Astrid Miller. I'm from Legal Services at the Department of the Premier.
You're most welcome. From Environmental Affairs. Mr. Rousseau, have you stepped away?
Apologies, Chair. Sorry. Dion Rousseau, representing Cape. Thank you.
Thank you. And I believe you are carrying the whole of the department's representation today?
It would seem so. I'm not sure, but it would seem so.
Thank you. And are there representatives from the Department of Agriculture with us this afternoon?
Yes, Chair. My name is Tsepo Morokong from the Department of Agriculture, Program Agriculture Economic Services. Thank you.
Good. Thank you very much, Mr. Morokong. You're most welcome. And then I do see a number of other names from people that have joined us that are not members of the committee and that have not introduced themselves yet. Would you be so kind, please? I see Mr. Mpela. Good.
Thank you very much and good afternoon, Chairperson and members. My name is Armstrong Pela. I'm with the SALGA office in the Western Cape. Thank you.
Thank you. Thank you, Mr. Mpela, and we always welcome the attendance and interest of the representatives from SALGA. A warm welcome to you as well. And then, honourable members, we are also joined by a number of support staff from the WC PP, the Provincial Parliament, Ms. Niekerk, Mr. Hassam, who through his work is making it possible for us to meet virtually, Advocate Maasdorp, who is our legal advisor, and then also Ms. Mshumpela, who is also rendering very valuable supporting services to us as a committee. Is there anybody that believe that I have unfortunately missed their name or not introduced them or given them an opportunity to introduce themselves? It seems to me everybody is happy. Thank you. Thank you very much for that then. Then, as I've indicated, we've received an apology was received from member Peter de Villiers. So please, Ms. Niekerk, if you could just note that apology, please. Then we've also extended an invitation to representatives in the National Council of Provinces, those that will have to take the debate forward in that forum. But the Honourable Labuschagne has indicated that she will only be able to join us after 1400 hours due to a prior engagement. And same applies with the Honourable Karin Visser, who will join us if possible. Good. Thank you very much. Honourable members, I believe you know that this meeting is being streamed on YouTube as well, and that technical assistance is available from the ICT staff. Good. So last week I gave and elaborated on the process followed this far. I'm not going to repeat that, and I'm going to ask that Ms. Niekerk now beam the draft committee minutes of the 15th of August for our consideration and possible adoption on the screen, as I believe it will assist us as a point of reference for the deliberation on the negotiating mandate reports. So, honourable members, there you see first the attendance. Page 2 is page 3. And then page 4, the resolutions. Good. And there, under the resolutions, first for the Agricultural Product Standards Amendment Bill, I believe those are the issues that we would like to concentrate on today. And then 4.2 is the National Veld and Forest Fire Amendment Bill. There were a number of sections where we took some input and where we decided that those should be addressed in our negotiating mandate. First, honourable members, may I ask whether there are any amendments that you would like to propose to the minutes? I recognise the Honourable America.
Thank you, Chairperson. I've noticed that Honourable de Villiers' name is not there. I can recall that he joined our meeting later in the proceedings, and there was mention of his. He did make a comment on the meeting. I'm not so sure, but my recollection is that he was in the meeting and his name is not on the minutes.
Thank you for that observation. And Ms. Niekerk, can you also recall? I do believe that the Honourable America is correct.
Chairperson, my recollection was that that pertained to the previous meeting, but his name was definitely not on our attendance list for last week. But I will double check, and if it was if he was in attendance, I will definitely add his name to this minutes. But according to Nomfundo's register, which she keeps as well, he was not present at the meeting on the 15th of August.
Oh, good. Thank you. Thank you. And unfortunately, he's not present to be able to confirm or deny whether he was present. So, honourable members, can I then ask that we perhaps just let the approval of the minutes stand over, particularly the section dealing with attendance, and then, but we will still be able to consider paragraphs 4.1 and 4.2 for this meeting in terms of formulating the negotiating mandate, I believe. Good. So thank you very much.
Chairperson, before we proceed, with notwithstanding what Ms. Nikak was saying about the attendance, I would like to propose that, you know, on the condition that that sort of omission or not is verified, that we approve the minutes, because, you know, with its content, there is not a problem. And I would like to propose that we adopt the minutes with any corrections that may flow from the conversation that may be had with Mr. de Villiers.
Thank you. Thank you, Honourable America. So what you're proposing is that we adopt the minutes, subject just to confirmation regarding the attendance register. Honourable Maran, you are recognised, and are you happy for us to proceed in that way?
Yes, Chair, I want to second that proposal, including that we verify. I can't remember that the Honourable de Villiers was present, but I have no problem to second this proposal and to verify whether the Honourable member was indeed present or not. Thanks.
Thank you. I trust the Honourable Marais is also happy for us to proceed on that understanding.
No, I got no problem, but I don't know whether this is relevant now, but the Standards Amendment Bill on, I don't know the word, 4B or 4C rather, they say that question any formation or an explanation. I think maybe it meant that they can request any information or an explanation, but you don't request a formation. And that is, I don't know, maybe it's something which you don't want to consider now, since we already went through the bill, but we did say in our resolutions they must look at the spelling. So I just see in section 4C, where they say in the case of action under subsection 1D and C, and then it says, and demand from the owner or custodian of the product, material, substance, or other article in question, or from the person supervising such management control system, any information. I think it should have been any awful information or explanation, but not any formation and explanation. I don't know.
Honourable Marais, would you perhaps assist me? I do not find a paragraph 4C in the minutes.
No, I wasn't talking to the minutes. I'm so sorry. I don't think we picked it up last time, but in the bill itself, the amendment bill itself, and I don't know, you're now discussing the minutes. Yes. But the bill itself, maybe you want to come back to it later.
We will.
Thank you so much.
We will certainly come back to that. So for now, we've just considered the minutes, and it seems to me there's agreement that we adopt the minutes, subject to confirmation of the attendance or not
Thank you,
Honourable
Chair.
de
I
Villiers.
agree.
Okay, good. Thank you very much for that then. Good. So now, honourable members, I first want to put to you the Agricultural Product Standards Amendment Bill in terms of us needing to compile a report that we will have to adopt this afternoon to forward to the delegates in the National Council of Provinces. So if you can quote from the agenda, sorry, the minutes of last week's meeting, there we already raised a number of issues. And I was wondering, Ms. Nicker, would you be able to just beam that section for us? I think you had it on our screens just now. Good. So my impression was that we support the amendment bill, but there were a few requests that we would like our delegates to go and negotiate whether they can insert that or change, amend the bill in this regard. And the first one is that the affected industries gain the right to ensure that the costs associated with the auditing process are within limits acceptable to the relevant industry. Currently, the bill requires of the assignee, which you will see there for those that are not familiar with the bill, the assignees refer to the entities that are required to audit the management control system, that the industry itself must also be able to make input into the costs associated with this process. As we know, quite often when people have a sole right to determine costs, it can run away. Now, the bill makes provision for the assignees to draft a budget in advance, but the question is who are able to comment on the budget and eventually approve the budget and make sure that those costs do not run away. And then the second one that we got, particularly from industry, and I think we as a committee aligned ourselves with that view, is that in the bill, it must put it clearly that the assignees must know the industry. They must know and possess the necessary qualifications and know the product. They must have enough knowledge of the industry in order to fulfill their tasks. And obviously, there must be no conflict of interest in that regard. Those were two of the proposals that we supported last week. Honourable members, first, are you happy with those two to be carried through to our report?
Yes, I concur, sir.
Thank you very much. And the Honourable America?
So, same my side, Chair.
Thank you very much. Thank you, honourable members. Please interrupt me or raise your hand rather if you believe that I'm going too fast or you would like to comment. I recognise the Honourable Maran.
Thanks, Chairperson. Look, Chair, I don't have a problem with the proposals made that we do support. With the following, Chair, in the report is it 4.1.1.1, and then also 4.1.1.2, that those that will go to the NPC, NCOP, go negotiate for those two to be included. But also, Chair, if we don't manage to get it included, that we still support. Chair,
Indeed. Yeah, we can ask that the report reflects that. Yes. Okay, honourable members, are there any additions to those two proposed amendments or issues identified that we would love to see amended? Are there any additional items that you would like to include in the report?
Not from my side.
Sorry. Must I raise my hand?
Not from my side, Chair. I'm happy.
No, not
Thank
from our side either, Chair.
Thank you. Thank you, Honourable Marais, for raising your hand and following protocol. Over to you.
Yes, sir. I just want in the amendment act, the amendment to the bill, section 4 of the bill, it says there, it uses a word, and I will read it to you. Demand from the owner or custodian of the product, material, substance, or other article in question, or from the person supervising such management control system, any formation or explanation. You can't demand a formation or explanation. You demand information or an explanation. I think that the word should have been information and not formation, but I accept what the committee think it should have been, because a formation is something totally different than information.
Ms. Nikak, would you be able to beam that section of the bill onto our screens? Honourable Marais, you are referring to the amendment bill?
Yes, amendment of section 3A of Act 119 of 1990 by section 4 of Act 63 of 98, and it's on page 3 of the amendment bill. And then they say there, section 4, and it refers to section 3A of the Principal Act. And the word in that paragraph should not be formation, that they demand any formation or an explanation regarding management. It's they must demand any information or an explanation regarding the management. You can't demand a formation regarding management.
Yes, yes. Honourable Marais, thank you very much. 10 out of 10 for your fine eye there. I tend to agree with you. I don't know if between myself and the Honourable Marais we are misreading that, but it seems to me as if Honourable Marais has got a valid point there. Our advocate will help us. Over to you, Advocate Marston.
Thank you, Chairperson. Having read the provision Member Marais referred to, Member Marais is right in that one cannot demand a formation, but if one should even look at the word formation in the broader context of that provision, then the only, and that word formation standing in relation to the following word explanation, then the only reasonable inference one can draw is that that is a typo and should in fact read information, any information or an explanation that can be demanded regarding management control systems. So I agree with the Chairperson, who in turn agrees with Member Marais.
Yes, yes.
Chairperson, if I could even just abuse this opportunity and refer the committee to something similar to what Member Marais picked up. And I will ask for this observation for my colleague Nikak to just scroll to the memorandum on the objects of the bill. And in particular, Chairperson, if we look at item 1.2, let me not just pretext what I'm going to say, Chairperson, that I am very aware that the memo on the objects of a bill is simply there to provide a narrative, to provide a context and backdrop for what the bill seeks to do, what it purports to do with its various provision. That is to assist, to give us context and to understand what the bill is seeking to do. I am also very aware, that being said, that a memorandum is not part of the act or of the eventual act that may come into being. So with those caveats, let me just draw the attention of the committee to the following, and I will read it. And this is in particular item 1.2. It reads as follows: various deficiencies in the Act which necessitated the amendments were identified. Now, we see, Chairperson, that the bill, in its long title, it speaks to the objective of providing auditing services and management control systems. And throughout the reach of this bill, there's countless reference to management control systems. In fact, the word audit is even included as one of the working definitions of the bill. If one then reads with that in mind, the second sentence of item 1.2 in the memo, it reads as follows, and I will read: a key deficiency was in the definition of management control system, which covered all management systems pertaining to inspection, audition, and production practices. I'm of the view that the word audition has got nothing to do with America's Got Talent or with any voice talent shows. Indeed, I think the word audition should in fact read auditing if one reads it in the context and in the sentence construction of that second sentence of the memo. That's my observation. I've, in my past life, been wrong about things, but I leave it to the committee to interrogate that, Chairperson. Thank you.
Advocate Marstorp, you may have been wrong on many counts, but I think this time I would agree with you that you picked up on certainly a typo, and that it should be the inspection, auditing, and production practices. And thank you for that. And honourable members, with your indulgence, I'll ask Ms. Niekerk to also include reference to that in our report to the NCOP. And I must admit, Advocate, I only read the bill itself, or not the memo to the bill. So thank you for that.
So that's just proof that we have the best legal advisor in the department. We never have to doubt him.
Thank you, Honourable Marais, and the Advocate takes note of that. And
I fully agree.
I don't know if there will be. Let me not hear about any brown envelopes and so on for that. Thank you very much, honourable members. Are there any other aspects that you would like to add? Advocate Marstorp, again, over to you.
No, Chair, that was a mistake on my side. Sorry, I was wrong there.
You can't. Your moment of glory was very short-lived. Thank you, honourable members. Anything else that you need to? Can we then say this is what we believe should go through to the National Council of Provinces? It seems to me that there is concurrence then with that view.
Yes, sir. From my side, yes.
You're happy.
From my side, yes, Chair.
Thank you very much, honourable members. Thank you. So with that, we will give Ms. Niekerk a little bit of time later on to just draft a report. I do know she's already got a template on hand, but following our debate, I trust that she will have to amend that slightly or add to that. May we now move on to the Veld and Forest Fire Amendment Bill? And Ms. Niekerk, would you be able to beam from our minutes of last week, paragraph 4.2 onto our screens? Thank you very much. And yeah, as wide as you can make it, so that the text is enlarged. Thank you very much. Good. So, honourable members, last time we picked up, like now, on a few typos, and we call it grammatical errors to be corrected. The detail of that we actually discussed it last week. They were in that matrix, and we agreed with that. Then perhaps the advocate could advise us on the next one. Advocate Marstorp, as you would have seen, one of the amendments proposed is that the short title of the Principal Act must be changed to the National Veldfire Act. And the proposal is that we then also change the short title of the amendment bill to the National Veldfire Amendment Act, so once it is approved, while it's currently reading, the Veld and Forest Fire Amendment Bill. Then the third one, I'll give you a moment or two to ponder on that one. Then there's a proposal that we change the wording of Section 4.8 to read, and I believe this refers to, for example, municipalities, to join a fire protection association if such an association has been registered in the area and which the land is situated. Then 4214, amending the Principal Act, where we expressed concern about the powers allocated to traditional leaders, and those powers are stated as enter, search, arrest, and seize. It was explained to us that unfortunately, when you're dealing with an arsonist, unfortunately, you need to act quickly and decisively. Now, the proposal is that they delete certain words from the Principal Act to say, for example, that such a person must not only identify him or herself, but also that they possess these powers. Now, in terms of the feeling was that since these are quite wide-ranging powers, that a person exercising or making use of those powers should not only provide proof of their identity, as stated in the Principal Act, but that they also provide proof of being found competent in terms of the Act. And as you will know, the Act speaks about training that people should have undergone successfully before they can act in terms of the Act. Okay, honourable members, can I first ask Advocate Marstorp for his comments? First on the potential name change of the bill. Can it be done before it gets finally adopted? And then I also recognize the hand of Honourable Murray. Over to you, Advocate Marstorp.
Chairperson, I must actually say that this is the first time that I encounter a proposal for a name change. And that being said, I'm of the view that the name of a piece of legislation is as integral to the legislation as the substantive content of that instrument is concerned, and is also therefore subject to be changed. It is in fact conceivable that a name or a title can and should and may be changed, as we know that with the flux of time, some titles may have denotations or concepts or words which have become obsolete, which have become socially sensitive, and that there should be, for purposes of lawmaking and within the domain of the lawmaker, there should be the competence, if you like, to change even the name or title of a bill, of an act via a bill. So I have certainly no reservations or qualms with that proposal to change the name as it is proposed there now, Chairperson.
Thank you very much. And although I see the Honourable Murray's hand is marked as number 1, I first recognize the Honourable Murray. Apologies for that, Honourable Murray. First Murray and then Murray.
Thank you, Chair. Chair, yes, I put my hand down and then put it up again. Chair, just from my side, and perhaps if we can maybe get the guidance from Advocate Marstorp in this regard, on 4.2.1.4, which deals with enter, search, arrest, and seize. It says in terms of this act, and I wonder if it should say in terms of this act and the relevant provisions within the Constitution that maybe deal with policing. just because I think that provides a more solid interpretation of when you can intervene in such matters. Thank you.
Thank you, and I'll again give the Advocate Marsdorp just some time to ponder that proposal. Honourable Marais.
Thank you, Chairperson. Just something that came into my mind after I read this bill more thoroughly. The Traditional Leaders Bill has been amended in 2015 to read Traditional Leaders and Khoisan Bill. So now I'm just wondering, are we back to the Traditional Leaders Bill and what they can do? Or should I have referred to traditional leaders and or Khoisan leaders? It's just a technical issue, but it could later come to bite us, because I know in the past, when I just former years entered politics, we had a title of Justices of the Peace, and they could perform this. They could intercede when there's trouble in any situation. Justice of the Peace, they don't have it anymore. But now I want to know, are we going to still stick to traditional leaders or traditional and recognized Khoisan leaders?
Thank you, Honourable Marais. I can just say that in the definitions, they now have changed the definition, two definitions. The one is traditional council, and the proposal is that now reads as means a traditional council as defined in Section 1 of the Traditional and Khoisan Leadership Act. And the next definition, and the words itself are Traditional and Khoisan Leadership Act, means the Traditional and Khoisan Leadership Act of 2019, Act number 3 of 2019. So I believe that your question has been addressed, but perhaps if I'm missing something, please correct me, Honourable Marais.
No, sir, I'm in no position to correct you, sir. We have legal guys here who can attempt that. I'm just pointing out something, but if it passed legal scrutiny and not cause another upheaval, then I will go along with your decision that it is covered. But traditional leaders definitely in the Act didn't cover Khoisan leaders. They were mentioned as a separate category of leaders, traditional leaders and Khoisan. But if you say that Khoisan leaders are also now deemed to be traditional leaders, then they would be covered.
Thank you. I'll pass that one also on to Advocate Marsdorp to perhaps just quickly scroll through the Principal Act to see whether this amended definition will apply to all the references to traditional leaders in that piece of legislation. Honourable America.
Thank you, Chairperson. Chairperson, I recollect that I raised a similar concern to the one raised by Honourable Murray, in the sense that with regard to the power to arrest without a warrant. My view is that if we are going to insert the matters raised by Honourable Murray, would then defeat the purpose of the explanation that we provided to my questions a week ago, in the sense that, and you raised it also as part of your introduction to this particular section, that if a person is caught with a jerry can of petrol, that certainly you cannot go to a magistrate or judge to get a search and seizure warrant, because by then, you know, possible evidence would not be at the officers or the fire protection officers' disposal. So therefore, if one includes the provision of the Constitution or the subject to the requirements that the police may have to comply with, and certainly it will to a certain degree defeat the object of this particular clause. And therefore I think having sort of listened to the explanation provided by the officials, I was satisfied that under certain circumstances, urgency is required to effect an arrest, and therefore I'm of the view that it should stand as it is, because it will then deal with potential catastrophic events in a more swift manner, and to that end. I support it. Thank you, Chair.
Thank you. Thank you. And then therefore over to Advocate Marstorp. Advocate, there are a number of issues that have been referred to you. Your response?
Chairperson, in the few moments I have had to just ponder this, let me just start off with the issue of traditional leaders. I note the observation by Member Marais. I have not been able in these moments to peruse the acts and bills maybe that he has referred to, because obviously I was listening for any further questions and tried to focus my mind on any further questions. I will say this though, that
apologies, Advocate Marstorp, won't you just repeat what you've said in the last 10, 20 seconds, because your connection unfortunately went bad?
Sure. Let me just then repeat. It's very strange that it went bad because I'm in the office where I would think that the connection is fairly stable and secure. Let me repeat, and Chairperson, I'm saying that in the few moments that I had since the question was posed by Member Marais, I did not, as would have been the proper thing to do, peruse any other bills or acts where the issue or the notion of traditional leaders is referred to or is being defined. So because I was intent on listening to any other questions from members in case I needed to respond to those as well. But I'm saying, that being said, I'm virtually sure that the act Member Marais is referring to came into being after the Principal Act came into being. So there may be a bit of inconsistency in the framing or in the referencing of traditional leaders or Khoisan leaders, etc. Even if there is an inconsistency, and if it should be that that aspect should find the need for application in a court, and a court should be confronted with the need to interpret it, I think the court will, with its, I'm sure, very, very competent powers of interpretation and with the use of the Interpretation of Statute Act, would certainly read a provision that it shall include all leaders who are defined as traditional leaders in the act that Member Marais speaks to. I think the reference here is maybe predating the bill that we are dealing with at the moment. That is a cursory observation, because I didn't peruse the definitions of this act or of the act Member Marais refers to, insofar as it deals with traditional leaders. Secondly, Chairperson, I note what Member Maria said, and I also note the response by Member America. I will say the following. Chairperson, you know, one should be very circumspect to glibly distribute the powers to arrest and seize and enter and search. Our Constitution is a very powerful document. One. And two, the right to freedom of movement is a very powerful right. And if I walk around outside on some other land mass, no individual can just approach me and arrest me. So in other words, I'm saying, one then presupposes limitations. If a police officer approaches me and attempts to arrest me, I would be very well informed and advised to go along with that police officer, because she or he may identify herself as a police officer, and I will have no grounds in that moment to doubt that assertion by the police officer, because I wouldn't want to be seen to resist arrest. A limitation to my freedom of movement when there's someone with authority who displays and articulates that authority, and I must go along. Along comes another person, purportedly a fire protection officer, who now seeks or attempts to arrest me. How am I going to know that the person is properly authorized to perform that act and deprive me of my freedom of movement? Well, the suggestion is that that person should, just as that person identifies herself or himself, should also display an accreditation of sorts to give a legal basis for performing the act of arrest. I would then be well advised to subject myself to that act. So, if we read it within that context, and we say that the Western Cape government expressed concerns regarding the powers allocated to the traditional leaders to enter, see, search, arrest, and seize in terms of this act, I have no concerns in that regard. I'm mindful of what Member Murray has said, the referencing to the Constitution, in as much as that sounds very, very useful. I sort of lean in the direction that it may be superfluous, because you see, Chairperson, any bill that this committee is confronted with or is sought or instructed to deliberate on is subject to the dictates, to the letter, to the spirit, the reach, and the purport of the Constitution. So to insert that would be useful. It would be nice sounding. I think it would be superfluous, because in any case, legislation are, with our beautiful rule of law doctrine, are subject to the Constitution's dictates. That's the extent that I can take it now, without any other deep-seated research on my side, Chairperson. Thank you.
I would concur with that, Chairperson.
Thank you. Thank you, Advocate Marston. Good honourable members, can we first then just deal with within 4211? I think there we are happy to support. If I can speak on your behalf, it seems to me, after listening to Advocate Marston, as if 4212 is also something for the NCOP to contemplate. Then same with 3, and then 4. I think it's important for us when somebody is going to arrest me, that first they must be able to identify themselves, so that if I want to make a case for unlawful arrest or seizure afterwards, that I would be able to name that person. And then secondly, it doesn't quite make sense to me why they must no longer prove that they are appointed as an officer that can act under this piece of legislation, but at least that they give proof that they have been found competent and therefore qualify for the power to be able to act under this act. And if I understood you correctly, Advocate Marstorp, you actually said that it may be superfluous to repeat the protection that citizens already have under the Constitution of South Africa. I see your hand is still raised.
Yes, Chairperson. Sorry, I was going to add the following earlier, and pardon my oversight there. You see, Chairperson, it is so critical that we do get our delegates to have that amendment of the accreditation effected. I imagine the following, where a private person is confronted and is shown accreditation. That is the perfect scenario. But where we have an instance, and of course we know about human nature and how abuse and how breaking of the law becomes second nature to some individuals. So, Chairperson, it is imperative that fire protection officers have accreditation from an accredited institution, but also, and this is the point I wanted to add, that accreditation should be frequently renewed or re-endorsed, because I envisage the following. On day one, we have hundreds of officers being fully accredited and given new uniforms, and they all are shiny and walking around in the veld looking for arsonists. In day 390, in other words, a year later, that officer, who has subsequent to day one been dismissed as an officer because she herself started a fire and was suspended from being a fire officer, but she kept her accreditation. And she can show it to any person. She can now just manhandle and say, I can arrest you. In the meantime, it is an abduction. So I'm saying we should not just have an issue of accreditation, but there should be annual reapplication, or there should be further training, which will then result in a renewed accreditation. It shouldn't just be a once-off for fear of abuse and for fear of further crimes being committed under the guise of an accredited fire protection officer's actions. So it is critical that we get that inserted, not just show identity, but also the accredited competence, which is renewed annually. Just like lawyers must renew their certificates, doctors must renew their certificates. Why not the veld fire person who will arrest me and deprive me of my freedom? That must also be annually certified for fear of abuse and whatever follows from such things. Thank you, Chair.
Thank you. Honourable America, you are recognized.
Thank you, Chairperson. I fully agree with the advocate, but I want to add this in a sense that if one look at the last sentence, it says that propose that those exercising these powers not only provide proof of their identity, but that they also provide proof of being found competent to the act. And I don't know if it is necessary. One could somewhere add that when exercising these powers, that such a officer or person should identify herself and wear some sort of name identification apparatus, whatever, brooch or whatever one could call it, so that whoever becomes a victim of such, not a victim, but a subject of such arrest could then certainly know who's doing the arrest and will provide certain certainty in terms of as to if, for lack of a better word, to challenge the exercise of the power laid in court, knows against whom that action needs to be instituted. The advocate can perhaps assist. Thank you, Chair.
Thank you. Perhaps the words must identify themselves and provide proof of their identity. Would that perhaps address that? We'll ask Advocate Marstorp to assist. Honourable Murray and then Honourable Murray. I recognize the Honourable Murray.
Seems absent.
Can we then proceed to Honourable Murray?
Yes, thank you. The issue of identification is easy. Policemen have a badge, got a number on. Traffic controllers, the same. It's simple that if it's going to be somebody officially recognized, that they should have a badge with their number displayed prominently. You don't have to ask him your name, you just take his number. And then you know who this person is, and an easily recognized badge issued by the relevant authorities should suffice, because conversations can lead to more trouble. Minute you ask a guy, what's your name? And then it's an argument. Why must I give you my name? I'm telling you, I am the officer. But if he has a badge and to identify himself, it's not necessary to ask the name. You can see the badge and you can record the number of the badge.
Thank you. The words visibly identify themselves come to mind, but I'll leave that also to the advocate. Honourable Murray, are you back?
Chair, can you hear me? Am I
We
audible?
hear you. We hear you loud and clear now.
Thank you. Chair, just one thing that comes to my mind from a past life is that citizens are empowered to make an arrest. And so one concern I have is that if we require identity for a citizen to make an arrest, whether they're a traditional leader or whatever capacity they hold, we might be undermining their right to make a citizen's arrest. And so maybe what we need to do is sort of separate out what a citizen can do within their power, so that such as an arrest, and what they may not do, perhaps a seizure, I'm not sure, and then perhaps what is required of them should they be performing functions outside of a citizen's arrest, which they're entitled to do. Thank you, Chair.
Yes, thank you. My impression is that your rights as a citizen is not addressed here. What we are talking about here is only the rights that, as it says, exercising powers under this act. So when you exercise power under this act, you must carry with him or her and produce on request the prescribed proof of his or her identity. That is how it's being put in the bill. So when you exercise your power under, can I call it common law, then obviously this does not apply. But that's my layman's understanding, and therefore I'm grateful that we have a person such as Advocate Marstorp with us in our meeting. Advocate Marstorp, over to you. You've heard various views. Please assist us in finding the right one.
Chairperson, maybe just this following observation, following Member Murray's input. I am aware that the Criminal Procedure Act provides for instances where a citizen's arrest may be effected. This bill is merely a specific entitlement to specific individuals to breach another person's freedom of movement. If the chair can just assist me on what the other question was, Chairperson, I just picked up Member Murray's observation earlier.
I believe it also dealt with the proposal that such a person must perhaps be able to be identified by way of a little bulky, I think, is it a breach, or other visible way in which such a person would be able to, when exercising the powers under the Act.
Yes, thanks for that.
For the right of the person that are being searched, or from whom certain possessions are being seized, that to make it easier for such a person afterwards to be able, when he or she wants to lay a complaint that somebody has, let's say, acted unlawfully, to be able to identify the individual or individuals concerned.
Yeah, I take that. In fact, thanks for reminding me. Chairperson, the last sentence there is, it is therefore proposed that those exercising these powers not only provide proof of their identity, but they also provide proof of being found competent. Chairperson, I'm of the view that that would be sufficient, because the issue of disclosure of identity is what we want to provide for. Issues of display, issues of identification, not personal identification, but of official identification, I would want to think that that may be provided for in regulations that may follow this Act, because it is certainly very much within the realm of minutiae and not necessary here. All that we need to concern ourselves with, this is my view, is that we ensure that the issue of identity and identification is provided for, simply because of the ability and the authority to effect an arrest. And that is a very powerful right that is being invaded. So therefore, we want to know who is this, and you want to know in advance when we see someone approaching that there's the glint and gleam of a badge. But that issue, I'm sure, can be very capably provided for in regulations, save for us to provide that we want issues of identity and identification and competence to be provided for in this Act.
Thank you, Advocate. I recognize the Honourable America.
Chairperson, I do not differ with Advocate Marsop on this particular one, but this is a negotiating mandate, and I'm leaning towards, even if it is considered as minute, is that we specifically state the wearing of a badge or whatever, if the final arbiters of this Act so deem that it is superfluous to contain in this particular amendment bill, then certainly at that point it can, taken out. Just my view. I'm open to be persuaded by the decision of the House. Thank you, Chair.
Thank you. In terms of advice previously obtained, and I think that relates to a core decision, is that we do not need to provide the alternate wording to the delegates to the NCOP. We just need to raise our, can I call it, questions or our proposals. And honourable members, I think, I hope I speak on behalf of a number of us when I say that I share the Honourable America's concerns that identification is extremely important, and that proving your identity should perhaps be a little bit expanded upon, to say, how do you want that person's identity to be able to be confirmed? So if I can ask that we add a sentence to that effect in our negotiating mandate, I would be happy to support that. I've already got the Honourable America support, and I also heard from the Honourable Murray, who even wanted us to refer to the Constitution, that this is a point where we want to guard against potential abuse. So Ms. Nikak, if you could make a note of that as well. But then, honourable members, if we step off these, because I think, Ms. Nikak, these were the points that we raised last time. Am I correct?
That is correct, Chairperson, yes.
If you go to the Principal Act, Ms. Nikak, and I hope you are able to beam that onto our screens as well. If you go to the Principal Act and you search for the words state land, then the definition of state land in the Principal Act, under definitions, unfortunately the definitions are all in alphabetical order, means land which vests in the national or a provincial government, and I'm going to exclude A, and then B, excluding land belonging to a local authority. Now, my understanding of this amendment bill is that the biggest change is that we now want to include local authorities, and particularly the land, or for them to form a fire protection association regarding the land that is also belonging to the local authority. And then obviously it also states other state organs, land belonging to other state organs as well. Do you perhaps have the Principal Act? Otherwise, ma'am, if you would be so kind to give me the right to beam onto the screen.
Chair, for some or other reason, my screen is just frozen now. I can't even get the mouse to move. But let me unshare, and then perhaps you can just beam it onto the screen, if you don't mind.
Certainly. Do you perhaps see my screen now? Honourable members?
Yes, Chair.
Okay. You will see, do you see state land there highlighted? No, I don't think.
Yes, Chair.
Chair, it's just gone away.
How come I don't see it on my screen? Welcome, Honourable Labuschagne. Okay, so there you will see under definitions where state land, it's Roman XV11, means land which vests in the national or provincial government, and then under B, excluding land belonging to a local authority. And the whole purpose now is for local authorities to become more involved with veld and forest fire arrangements, such as the fire protection associations. So perhaps if we could just raise the whole issue, and state land, there isn't a new definition in the bill that we have. I can perhaps just jump to the bill. There's no amendment to the definition of state land. I'll quickly try and share again. Share my screen. Okay. There you see again the definitions: fire, municipality, public entity. And then if we go on to the next one, you know, there's no S for state land. And in the Principal Act, again, if you go and look for state land and you look for the fourth one, the owner in respect of state land must join any fire protection association registered in the area in which the land lies. It seems just to me as if we must raise with our delegates in the NCOP that perhaps the definition of state land in the Principal Act, sorry, I'm going to jump back, that definition may need amendment as well. So it doesn't exclude land belonging to a local authority, but that state land also includes land belonging to a local authority. Honourable members, Any comments that you would like to raise in this regard?
If there's no
Honorable
comments in that regard, I'd like you to allow me just to bring something to the attention of this committee, sir, relating to the quality.
Sorry, your voice disappeared. Relating to the.
Sorry, regarding to all these things they mention here about certification, the quality, the control, and all those management control systems. These are all, this law is written for established white farmers. They now have all these things and have all the capacity. But emerging farmers from the colored and black communities, they haven't got it. They will be pushed right out of the market with all strict controls because they don't have the money. They don't have the money for all these auditing and inspections, certifications that this bill requires. And I'm speaking in a broad sense. I'm not referring to any specific clause here, but it's right throughout the bill. It's just about auditing and management and quality and these poor colored farmers who only now enter the red rooibos market. How do their markets get graded? Their products get graded? Must it go through white commercial farmers only because that is the standard? How will we ever help these people with all these new strict quality control systems for people who scarcely can manage to buy a tractor? Is this something that seriously bothers me? Maybe Mr. Moran also want to come in.
Okay. Honourable Marais, I think you may be back with the Agricultural Product Standards Amendment Bill, which we've actually dealt with. Can I just say, in terms of that, remember this now, that bill refers to when people want to claim that their product is organic, etc. And it's because of the danger of these assignees increasing the costs for their quality management work that this amendment bill has been proposed, so that they will also be able to, can I call it, approve the budgets of the assignees, or at least make some input as to those budgets. We're currently dealing with the Veld and Forest Fire Amendment Bill, and there I can just tell you that it's my impression that the advantages of belonging to a fire protection association is that, for example, if you own land, you don't need to make your own fire breaks, etc., and that you will be supported by the National Department of Environmental Affairs in protecting your land against veld fires, etc., by neighboring landowners cooperating with one another. Honourable America, I see you lowered your hand. Are you happy with that explanation?
Yes, Chairperson. I was just going to say is that the current bill that we're dealing with is not related to what Honourable Marais was saying, but certainly in terms, I agree with you completely that the previous bill and the current one does not disadvantage or advantage a particular sector of farmers or agricultural sort of product producers. It is generic in a sense that it seeks to protect all land owners, particularly in rural areas and in traditional areas. It has nothing to do with race, and bringing up emerging farmers and colored and black farmers. It is completely not within the spirit of and the content of these amendment legislation bills. Sorry. Thank you, Chair.
Thank you. Thank you. Thank
So
you, Honourable America.
I do apologize that I brought up the previous bill, right? Just came into my mind. But yes. I didn't talk of race. I talked about financial ability and viability. If that belongs to a specific rate, Mr. America must accept it. If it is general that everybody in this country is rich, then okay, he must convince me.
Thank you. Thank you, Honourable Marais. Thank you, honourable members. We're back to our negotiating mandate. And Ms. Nikak, if I can just put it clearly that, for example, we also ask that the definition of state land in the Principal Act be reconsidered to perhaps include land belonging to local authorities. Good. So, honourable members, are there any further proposals regarding the mandate? If not, we are going to give Ms. Niekerk some 10 minutes to just prepare the reports, because we would love these reports to also serve before the committee today for consideration and then possible approval. And then those reports would be ready to be submitted to our representatives on the National Council of Provinces. And honourable members, with that, again, a warm word of welcome to the Honourable Labuschagne, who is representing the Western Cape in the National Council of Provinces. It's not often that she's able to join us. We did apologise and explain to the members that you submitted an apology that you would only be able to join us from 2 o'clock onwards. But I do hope, Honourable Labuschagne, that you've already benefited from joining us and following the discussions on this platform. Thank you.
Thank you.
Good. Honourable members, this is now, according to my clock, 14:17. Ms. Niekerk, 10 minutes, 13 minutes. How much do you believe you would need?
10 minutes is fine, Chairperson.
Good. Thank you very much. Honourable members, can we then temporarily adjourn this meeting and then reconvene at 14:27 to consider the reports? As I've said, Ms. Niekerk has already prepared some draft reports, which she will just have to amend somewhat. Thank you very much. We'll see each other then in 10 minutes again. Thank you. Erk, I think your phone may still be on. Thank you. Ms. Nikak, won't you be so kind to just scroll up to the top, because I want to read this report into the record as well. Thank you very much, honourable members. We reconvene after our 10-minute suspension of proceedings. And I'm going to read the report, and please raise your hand the moment you believe that there's something that you would like amended to this report. Report of the Standing Committee on Agriculture, Environmental Affairs and Development Planning on the Agricultural Product Standards Amendment Bill B15B 2021 NCOP, dated the 22nd of August 2023 as follows. The Standing Committee on Agriculture, Environmental Affairs and Development Planning, having considered the subject of the Agricultural Product Standards Amendment Bill B15 2021 NCOP, referred to it in accordance with the Standing Rule 217, confers on the Western Cape's delegation in the NCOP the authority to support the bill. The committee further proposes consideration of the following. 1. Clause 1 definition, audit. It is submitted that affected industries gain the right to ensure that the costs associated with the auditing process are within limits acceptable to the relevant industry. The mere drafting and submission of a budget will not put the relevant industry in a strong enough position to ensure that unnecessary costs which will have to be recovered from consumers are not incurred. 2. Clause 2, Section 2 of the Principal Act. It is submitted that it be more clearly put that assignees possess the necessary qualifications, product or industry knowledge in order to fulfill their task, as well as being free from any conflict of interest. 3. Clause 4, Section 3A of the Principal Act. It is submitted that on page 3, line 50, the word formation be replaced with the word information. And 4, memorandum on the objects of the amendment bill. It is submitted that on page 5, point number 1.2, second sentence, that the word audition be replaced with the word auditing. Honourable members, I believe those are the proposals that we want to pass on to our delegate in the NCOP. Any comments on this? No comments. I take it then as concurrence.
Chair.
I see, I hear Honourable Maran.
Yes, Chair. Remember what I've said earlier on in terms of issues that some of the issues that should be negotiated, and whether we manage to get it right or not, that we still. And you then said that yes, but let's rather put it in the report.
Can I just ask Ms. Nikak to scroll up again, because I believe it is in here. Perhaps we confers, it's the second line before paragraph 1, confers on the Western Cape's delegation in the NCOP the authority to support the bill. So I trust that your concern has been addressed.
If you say so, Chair.
Yeah. Do you see it on your screen? Are you able to follow?
I see, Chair. I see.
Okay, good. So I trust that your concern has been ably addressed. Honourable members, can we then get a proposal that we adopt this report? Honourable America.
Chairperson, I propose that we adopt the report.
And I see the hand of the Honourable Murray.
Seconded, Chair.
Thank you very much. Any other views? Duly adopted. Thank you very much, and thank you, Ms. Nikak, for excellent work there in the background. Honourable members, we then go on to our second report, the one on the Forest and Veld Fire Amendment Bill. Good, and I'm again going to read this into the record. It's somewhat longer than the first report, so please your indulgence. Report of the Standing Committee on Agriculture, Environmental Affairs and Development Planning on the National Veld and Forest Fire Amendment Bill, B24B 2021 NCOP, dated the 22nd of August 2023 as follows. The Standing Committee on Agriculture, Environmental Affairs and Development Planning, Having considered the subject of the National Veld and Forest Fire Amendment Bill B24B 2021 NCOP, refer to it in accordance with Standing Rule 217, confers on the Western Cape delegation in the NCOP the authority to support the bill. The committee further proposes the following amendments. Grammatical 1.1, long title, last line. It is submitted that the word matter be replaced with the word matters. 1.2, clause 2b, definition of municipality. It is submitted, perhaps, ma'am, if you would just add the verb there. It is submitted that the word system be replaced with the word systems. 1.3, clause 3, amendment of section 3 of the Principal Act. It is submitted that on page 3, line 19, a space be inserted before the word established. 1.4, clause 4, amendment of section 4 of the Principal Act. It is submitted that on page 3, line 33, the year 2021 be replaced with 2023. 1.5, clause 6, amendment of section 11 of the Principal Act. The term department on page 3, line 51, refers to the national department which has responsibility for the management of veld fires as per the Principal Act, and not the department responsible for the administration of the South African Weather Service Act 2001, Act 8 of 2001. It is therefore submitted that the first letter of the word department be a small letter. Good. Is the word small letter the right one? Shall we not say lowercase letter? Be a lowercase letter. Thank you. Then 1.6, short title and commencement. It is submitted that on page 4, line 34, the year 2021 be replaced with 2023. Substantive proposals. 2.1, clause 4, amendment of section 4 of the Principal Act. The proposed section 4.8 states that 8, the owner in respect of state land, a state-owned enterprise, a public entity, or an organ of state must, within a year after the commencement of the National Veld and Forest Fire Amendment Act 2021, join, and then that the word any be deleted, a registered fire protection association, delete the word registered, in the area in which the land, and again, is situated. So again, the word lie is deleted. Then it is submitted that the wording be revised as follows, and it's just a simpler wording, we believe, honourable members. Join a fire protection association if such an association has been registered in the area in which the land is situated. 2.2, clause 9, substitution of section 37 of the Principal Act. Given that the short title of the Principal Act will be changed to the National Veld Fire Act, it is submitted that the short title of the amendment bill be changed to the National Veld Fire Amendment Act 2023. Then under 2.3, clause 7, amendment of section 26 of the Principal Act. In terms of the proposed amendments to section 26(2)(a) of the Principal Act, various persons, including traditional leaders, are given the power to enforce the Principal Act. Concern is expressed relating to the powers associated to traditional leaders to enter, search, arrest, and seize. It should be noted that these powers may only be exercised by those provided that they have been trained to be competent by an accredited institution. And that quote comes from the bill. The National Department deemed these powers to be required to, for example, act against arsonists in rural areas. It is submitted that those exercising these powers not only provide proof of their identity, but that they also provide proof of being found competent in terms of the Act. It is therefore submitted that on page 4, line 14, the following be inserted after the word identity, and the insertion would be and proof of being found competent. Then under 3, general, it is submitted that the definition of state land in the Principal Act be reconsidered to include land belonging to local authorities. Honourable members, that is the draft report. Any further comments? Yes, please, Honourable Murray, please proceed.
Can we just move down to 2, please, before we get to general? Right. But let me just see there. concern is expressed relating to the powers located traditionally to enter, search, arrest. It should be noted that these powers may only be exercised by those provided by those. Doesn't make sense. It should be noted that these powers may only be exercised by those provided that.
I hear. I think you've got a valid point there.
Yeah. The sentence must read differently. It by those persons, so and so, provided that they have been trained by those accredited or something like that. You can't say by those provided that they have been exercised. By those who?
Shall we perhaps say by those
Chair,
meeting the requirement in the bill and then a quote. Honourable Laskagni?
I think we just have to concern is expressed relating to the powers allocated to the traditional leaders. So that those refers to traditional leaders. 2, and then the quote, enter, search, arrest, and seize. It should be noted that these powers may only be exercised by those, that's traditional leaders, provided that they have been trained to be competent by an accredited institution. I'm asking, is the fact that we are looking for who are those, it's actually referring to traditional leaders in the Act.
I think it's an excellent proposal.
I would say by those tradition, by those, no, they must say.
Honourable Marais, just a
Yes,
moment. Just a moment. Let's consider, because I think the Honourable Laskagni has got it spot on. May only be exercised by traditional leaders. So the word those be replaced by traditional leaders, and then it continues, provided that they've been trained to be competent.
Yes.
How does that read to you?
Yes.
I think she's got it spot on. Are you happy,
Yes, that's
Honourable?
right.
Yeah. So thanks for picking up on that, Honourable Marais. Good. And then are there any further aspects that you would like to highlight, Honourable Marais? Can I just ask the Honourable America a concern about also the identification of those that exercise these powers, you know, and we did discuss the possibility of, may I call it, a visible form of identification. Honourable America, do you perhaps want to assist us there in the last paragraph?
Chairperson, I think if you read it, it is therefore submitted that on page 4, line 14, the following be inserted after the word identity and proof of being found competent, that such identity should be visibly displayed on the person, or should be visibly displayed, should suffice, Chairperson. Yeah, perhaps the.
Do you believe that address your concern sufficiently?
It does, Chair. Thank you.
Wonderful.
Mr. Chair, why do we have to give an example? The last sentence. The National Department deemed these powers to be required to act against arsonists. Why put, for example? Is there others examples? If you say, for example, it means there's others also, but this is only an example. You either say it's only them who can do it, or others also, but we only use them as an example. I think that, for example, must come out.
May I ask, how would you feel if we delete that sentence in full? Because that was actually more of a motivation. But in terms of just changes, I think the Honourable Labuschagne here, she's now taken note of that. So it's not necessary for us to include that in our report. So my proposal is that we perhaps delete that sentence.
I agree
I would
with
support that, Chair.
Honourable Marie. Thank you.
Okay, good. So thank you very much, Ms. Niekerk. Any further comments, honourable members? Honourable members, are you therefore then happy for us to adopt this report as this committee's view?
Powers not only provide proof of that spells. I would say not only, sir, is weak. It is submitted that those exercising these powers must provide proof of their identity. And that they also provide proof of having been found competent in terms of the act. Must is much stronger than not only provide, sir. They must do it. In law, must and shall and may has different meanings.
I'm just scrolling down to that section.
2-3 paragraph 3, sir.
Yes. Can I just perhaps read from to you the proposed amendment in the bill? It says a fire protection officer and any officer or traditional leader contemplated in subsection 2A exercising powers under this act must carry with him or her and produce on request the prescribed proof of his or her identity.
Yeah.
So fortunately, the word must already appears in the bill, and therefore I think we don't need to reiterate that. If you are with me, Honourable America.
I'm good, Chair. Thank you.
Good. Honourable America, must we beam the bill onto the screen, or are you happy for me just to read it to you again? So they must carry with him or her and produce on request the prescribed proof of his or her identity, and then we just add and proof of being found competent.
Yes, Chairperson, then the last edition that I proposed becomes superfluous and we can take it out completely and then just stop at competent. Yeah.
If you're happy, I'm happy, Honourable America. I think that is how you had it, Ms. Niekerk. Can you just so and proof of being found competent? Ms. Niekerk, are you with us? There you are.
I am, Chairperson. I'll just delete the second part of the sentence here.
Correct. Any other proposed amendments, honourable members? Advocate Marstorp and then Mr. Dion Rousseau.
Chairperson, just the phrase it's used twice in the last two paragraphs. Also provide proof of being found competent in terms of the act, and also the last one, and proof of being found competent. I think a better construction, grammatical construction would be, and also provide proof of confidence. Proof of competence in terms of the act and proof of competence.
Okay.
I think being found is a continuous participle and not necessarily good drafting style. Just in terms of the tenses of the provision that we want to propose. So provide proof of competence.
Just just the way it is there? Are you happy? Thank you. Mr. Rousseau?
Thank you, Chair. If I may, we must just make sure that the word, because I did see the word earlier, arson or arsonist. I just want to confirm that that's been taken out of these minutes. The word doesn't appear in the bill or in the act, but I did see it in these minutes.
In the draft
definition
report.
of arsonist.
Yeah. It has been deleted. That whole sentence has been deleted, including the word arsonist.
Thank you.
Thank you. So that concern has been addressed. Any other concerns, proposals, amendments? Honourable Advocate Marsdorp.
Just the preceding line as well, to replace the words provide proof of being found competent with proof of competence.
Yes, thank you.
Thank you.
So can I ask a question, Chair?
Please proceed, Honourable America. Oh, sorry, Honourable Murray.
I just want to get assurance from Advocate whether he has now satisfied himself that when you say exercised by traditional leaders, it would automatically include traditional leaders as it meant to be in terms of the traditional leaders in Khoisan Bill. Does it also include Khoisan leaders? Advocate Marsdorp had little time to check this out, and I understand that. But he says this bill was before the 2019 Traditional Leaders in Khoisan Bill, so traditional would have to refer to traditional and Khoisan leaders. I just want to be absolutely sure about that aspect, sir.
Thank you for raising that. So it seems to me, Advocate Marsdorp, we will have to go and see what the definition of traditional leaders may be in other legislation, such as the 2019 Traditional and Khoisan Leadership Act. Because under definitions, it only refers to the act and not the word traditional leaders have not been defined in this bill.
Glossary of terms don't define traditional leaders. That's my point, sir.
Would you mind repeating that, Honourable Murray?
I say the glossary of terms which always precede the act define words, and traditional leaders has not been defined there. He didn't say as defined in Act so and so. He just says traditional leaders, and it stands separate from Khoisan leaders, sir.
So it seems to me, Honourable Murray, we've got two options. The first option is to spell it out here to say that we propose that where the words traditional leaders appear, that they include Khoisan leaders as per that definition. And then the other one is to perhaps refer to another piece of legislation under the definitions. So we can either include the word traditional leaders here, or we can use it. We can have a separate definition of that. I wonder if Advocate Marsdorp might be able to give us his opinion while he's still thinking. Honourable Murray, you recognized?
Chair, thank you. Thank you, Chair. Chair, just from my side, my 2 cents is that I do feel we should make it subject to legislation, just because I wouldn't want us or our committee to be in contradiction with any legislation. Thank you.
Advocate Marsdorp.
Chairperson, thank you very much. Could I maybe offer the following? If I should employ my interpretation of statutes abilities, then I am quite confident that a presiding officer who may be called upon to interpret this legislation and who may be called upon to interpret the issue or the reference of traditional leaders, then one can look at a text. One does then look at a textual reading. One looks at a contextual reading, and one looks at the purpose of a bill and whether those three things merge and are sufficiently consistent and coherent to tell us and guide us what the Act purports to achieve. This amendment bill now, other than before, seeks to include those people who also own land and are traditional leaders. In other words, this bill does not want to have an instance where certain landowners are excluded. That being said, the reference, this is my view, to traditional leaders as it stands here, with it being a lowercase t for traditional and a lowercase l for leaders, would, in view of the spirit of the Act, the general purpose of the Act, would necessarily include all leaders traditionally owning land. And such an interpretation would then necessarily include Khoisan leaders as well. That would be a liberal interpretation, mindful of the mischief that is being sought to be addressed by involving, including also traditional leaders, and that this term, had it had a capital T and a capital L, would have been somewhat inconsistent with what is sought to be provided for in the Traditional and Khoisan Leadership Act, Leaders Act. So I am quite confident, and I'm in fact quite comfortable in terms of interpretation, that this bill does not, even by implication, exclude Khoisan leaders. So that being said, and if one would want to satisfy the expectations of Member Marais, then I would say that we then also assist our delegate to convey, as per this narrative, the message that the Western Cape Provincial Parliament, in as much as we believe that all traditional leaders are included by implication, we should maybe just do an express inclusion by having traditional, one could even say, and other, or not, traditional and Khoisan leaders, so that there's an emphatic inclusion and not an implied exclusion.
Thank you for that. Advocate Marsdorp, may I ask that you just perhaps glance at the bill, particularly on top of page 4, amendment of Section 26 of Act 101 of 1998, 7, and then it says Section 26 of the Principal Act is amended, and then they say a forest officer, a police officer, a peace officer, a traditional leader as defined in Section 1 of the Traditional Khoisan Leadership Act, and an officer have the power to enforce, provided they've been trained, etc., etc. So it seems to me as, although it's not in the definition, you know, can I say it in chapter 1, that here it says a traditional leader as defined in section 1 of the Traditional and Khoisan Leadership Act. So where they refer to traditional leader, and I will hope that that will also be drawn through to paragraph 2b and paragraph 3, when they refer just to traditional leader, that that every time that definition of a traditional leader as including Khoisan leaders would apply. Your comment on that? If
that is indeed my reading as well, Chairperson, that it is a reference with an implied inclusion as opposed to an implied exclusion. So that is certainly my reading as well, yes.
Yes. So it first says it explicitly, and then in the following 2 paragraphs, you say it's implied then that it's referring to the same group of leaders. Good. I see a thumbs up. So it seems to me, Honourable Marais, that one has been addressed, and I'm grateful to you for raising it, so that we can get clarity on that.
Thank you, Chair, because I just want Advocate Marstorp to also, why I bring this up, there has been a challenge a month ago in the Constitutional Court, which the Khoisan communities won in the Constitutional Court. And the court threw out and said that certain sections in that act was unconstitutional, invalid regarding land rights here in the Cape. So I just wanted to make absolutely sure that we've covered our bits. But like I say, I trust our legal people, and I just brought it to their attention so that if something goes wrong, at least I know I said something could go wrong. Thank you.
Thank you. Thank you very much, Honourable Marais. Honourable members, can I ask you to therefore then consider this report as it's been beamed on your screens and as I've read through it? Are there any further comments? None. Can I then put it to the meeting for consideration?
I propose that we accept it, sir.
Thank you, Honourable Marais. Is there any other views, Honourable America?
A second, Honourable Marais' proposal, Chair. Thank you.
Thank you. Thank you, Honourable America. Any dissenting views? Can we therefore minute that this report is unanimously supported by this committee and adopted? Again, no comment. I take it as concurrence. Thank you very much, Ms. Niekerk and honourable members. I think I speak on behalf of us all if I say thank you very much to Ms. Niekerk for capturing all of that and for being so efficient and quick to be able to beam that onto our screen so that we could consider those 2 reports. Honourable members, which brings us to the next point on the agenda, and that is general resolutions. Are there any proposals that you would like to make, resolutions that you would like to put forward?
Nothing from my side, sir.
Thank you. Ms. Niekerk, would you mind just giving us a little bit of feedback on the proposed oversight visit? Honourable members, sorry.
My hand is up. Chairperson, I'd like to resolve that we express our appreciation to all those individuals who provided feedback on these bills, as well as the department, and because their feedback played an invaluable part in us formulating our negotiating mandate. Thank you, Chair.
Thank you for that proposal. Honourable members, can I assume that is supported by all members? And thank you very much for that. Good. Honourable members.
If I can add a
yes.
Thank you. I'd like to add to Honourable America's resolution that we also extend our thanks to all the procedural and legal staff who have guided us throughout this process. It's not been easy to deal with 2 bills at a time, so we're very grateful. Thank you.
Good, thank you very much. So, honourable members, just before we completely step off the negotiating mandates reports, this information will be transferred by the NCOP liaising officer to the negotiating mandate forms as prescribed by the Mandating Procedures of Provinces Act. I will then sign the forms and the NCOP liaising officer will submit the forms to the select committee at the NCOP. This NCOP select committee is scheduled to meet on Tuesday, the 5th of September, 2023, to consider provinces negotiating mandate stage reports on the National Veld and Forest Fire Amendment Bill. And then the relevant NCOP select committee will also consider provinces negotiating mandate stage reports on the Agricultural Product Standards Amendment Bill on the 26th of September 2023. We do not know when the dates for the submission of the final mandates will be communicated, but we will keep you informed in that regard. Good. Then, honourable members, if we can step off the negotiating mandates, just to refer you also to the draft report that was circulated some 3 weeks ago on the visit to California. Those of you that were privileged to accompany me on that study tour, please go and have a look at that report. If you require another copy, please request that from Ms. Niekerk, and please see if that captures, our experiences and our decisions and so on sufficiently. So please go and study that. Then can I perhaps just, before we adjourn, ask Ms. Niekerk just to perhaps inform us regarding the intended oversight visit. And from my side, I want to say, honourable members, thank you very much for being willing to assist during constituency week coming up. Unfortunately, there isn't much constituency left in that week, because in my case, I now need to either meet or travel every day of that week. But Ms. Niekerk, perhaps you can just tell us about the arrangements. I do know that Ms. Niekerk has been struggling to find suitable accommodation and so on in either Citrusdal or Clanwilliam. It is the flower season, so there are lots of tourists, and unfortunately there are limited options for accommodation. But Ms. Niekerk, perhaps you can just quickly take us through the intended program.
Certainly, thank you, Chairperson. The program at the Algeria camping site would then involve an observation of the damage that was done by the floods. And as Chairperson mentioned in the meeting last week, the reserve manager has been requested to provide the committee with pictures that were taken shortly after the June 15th flooding, so that the committee can now assess the structural work that has been completed and the improvements. And that visit will also include a visit to Sassewer, so that the committee can then assess the impact of the floods. The program for the day will also include a presentation on the effect that the floods had on tourism revenue and biodiversity, and it will, as I said, include an update on the structural damage that occurred. And then the visit, the agricultural part of the visit, there have been 2 farms that have been identified. The one is called the Middle Post Farm, and the other one, and Chairperson, help me, I'm not sure about the pronunciation. It's called the Dunkart Farm. So those are the two farms identified by the Department of Agriculture that they would like to actually take the committee to, show them the impact of the flooding, and then also have a meeting with the Citrusdal Growers Association around the issues they are experiencing, and certainly they will touch on the export of citrus and give us an update in that regard. The meetings, we're not sure of the weather at the time, but the meetings, we have secured a meeting venue, which would be at the Citrusdal Water Association offices, where we will first receive a briefing and then go out to the two farms. Accommodation, like you mentioned, Chairperson, is a challenge, but I'm working on that at the moment. And as soon as I have some feedback, I will relay that to our committee members. We are looking at Beatty Dam in Citrusdal. Pikanierskloof is not an option because it's fully booked for that entire week. And then we're also looking at the Clan William Hotel as another option. And there was one other, Chair, that you mentioned, and I just forgot the name now.
I believe that might be a little bit outside of the range of
Yeah.
That's Bushmanskloof Lodge.
That one.
Correct.
So as soon as I have feedback, I will provide that to the members in terms of the accommodation. But I will definitely ensure that it's accommodation of a suitable standard. So members need not worry about that. All right, that's all from my side, Chair. Thank you.
Thank you. Thank you, Ms. Niekerk. Honourable members, I have been on a reconnaissance for this last weekend. And can I say, for the visit to Cape Nature, I want us to perhaps consider dressing informally, jeans. I had jeans and tackies, and I was at one stage really sorry that I didn't put on hiking boots, because some of the soil that have moved it and that are blocking the road, etc., have really, it's like a little mountain with lots of loose stones, etc., that one has to cross if you want to obviously get a full picture of the extent of the work that will be required to undo the flood damage. May I perhaps just get an indication of those of you that are familiar with the Algeria campsite, the former forest station, because if time allows, honourable members, I would really like the reserve manager not only to show us the damage, but also the facilities that they offer to guests at Algeria, so that it's such a unique opportunity to get to a place where I think perhaps only a few of us have been to. That Ms. Niekerk, you can perhaps just ask him to open up one of the, can we call it, tourist accommodation chalets and so on, because honourable members, I think it is really something that we as a province can be extremely proud of. Okay, so it seems to me it might be a first visit to the campsite and the facilities itself. And then also, I know a number of you may have visited the Uitkyk Pass from when you travelled with the Committee on Infrastructure, but really the damage in that area is vast, and it will require lots and lots of money. And we can just hope that eventually our application for flood relief in terms of disaster funding would be approved. Thank you very much, honourable members. Any other points that you would like to raise? Honourable Marais?
Has the date now been fixed, sir? 7th September for the visit?
Correct. We are leaving, I think, is it 14:30 or 13:30 on the 6th, and then we will only be returning on the late afternoon of the 7th. And I did note your apology, Honourable Marais. Apparently, that's a very special period in your life.
I want to say, gentlemen and ladies, that my family, it's my birthday, the 4th September, but because they all want to be here, we had to give it on a Saturday. I can't give it on a 4th. So my own children and grandchildren already amounts to 27 of them. So I will have to ask you to excuse me because they'll all be converging here in the Cape and they've organized for me a party. So otherwise I would have gone with, but that date, unfortunately, the 8th is fixed and I cannot miss my own birthday.
And is it one that is dividable by 10?
Yes, 80.
Thank you,
Thank
Chair.
Good. Honourable members, thank you very much. Thank you for your attendance. Thank you for your participation.
Chair, before you conclude, I just
Yes.
wanted to check with you the time that we are leaving. Because as far as I can remember, Chair, there was a request from the Honourable Murray that we leave later. I'm not sure whether I'm correct.
15, I think it's 15:30, is that correct?
That is correct,
Yes, thank you, Chair.
Chairperson.
Yes, yes.
15:30, not 13:30. 15:30. Thanks.
Good. Thank you very much, honourable members. Have a great day and stay warm. See you again.
Thank you
Chair.
so much. Bye-bye, colleagues.
Thank you, Member Moran. Thank you, Chair. Bye.
Thank you.
Thanks,
Thank
Chair.
you. Bye-bye.
Nice day to everyone.
And to you, member. Thank you, Nomfundo, for your support.
Okay, sorry, I'm looking for Siraj here. Okay, it's a pleasure.
No, it's fine. You must tell me when I can exit the meeting.
Yeah, wait a bit now. I'm trying to
Okay.
get hold of Siraj.
Okay.